Ladies and gentlemen, welcome aboard the Pilot Lawyer Podcast. Thank you for your attention while this important legal information is reviewed. What you hear should not replace consultation with an attorney and should not be considered advice for your situation. On behalf of the Pilot Lawyer and your entire crew, it's our pleasure to have you aboard.
Welcome, aviators, to the Pilot Lawyer Podcast with us, the Ison Brothers, at the Ison Law Firm, where aviation law is all we do, nothing else. You're here for what we do best, navigating the FAA medical certification process for pilots and those who want to become pilots. And of course, if you don't laugh, you cry. And for the next 30 minutes, we hope to bring you the lighter side of what can otherwise be a frustrating process.
I don't feel like laughing today.
Today's not a laughing matter. So whether you're laughing at us, it looks like, or with us,
or
but
it
looks like you're going to be laughing at us.
Yeah.
Join us, brothers, as we discuss the fascinating world of FAA medical certification. Well, today we're toning it down a little bit. We're not going to be so jokey,
flippant.
you know. Yeah, people on the interweb don't seem to like us anymore.
Bird
not
dog.
that they ever did.
You got such a fragile ego.
Yeah, nobody can say anything.
One
upsetting.
person says something.
Yeah. Well,
All
anyhow,
falls apart.
It's three. We're up to three, okay?
even still, though, we're among distinguished individuals today because today's another guest episode where we have Derek Debus, who is actually a VA disability attorney that is going to help us sort of navigate some of the waters between FAA medical certification and VA disability benefits and how that intersection is relevant to one another. And I will also note that we're going to get into some pretty relevant questions.
Digging deep.
We're going to dig deep into some questions that we get a lot from veteran airmen as to how the disability process will affect your airman medical certification with the FAA and vice versa.
Something tells me you're going to do all the talking on this, and I'm just going to sit here and look pretty.
Yeah, you can join the ranks of Alex on this episode.
Yes.
Sit there and do nothing.
Welcome. It's a happy place.
Nevertheless, we're looking forward to welcoming our special guest, Derek Debus. Derek Debus is a dedicated military and criminal defense lawyer with a passion for protecting the rights of his clients. Derek primarily practices in the areas of military law, veterans' benefits, and criminal defense. So I would note that Derek is an attorney in Arizona with Stone Rose Law, and we're really looking forward to having him join us today. Let's see if he'll answer the phone or if he's come to his senses.
He's blocked us on call already.
This is Derek.
Hey, Derek, how are you?
Hey, doing well, man. How you doing?
I'm doing well, thanks. Well, thanks for agreeing to join the podcast today. We're excited to have you here because, especially with the climate of FAA medical certification as it relates to VA disability benefits, and we think you're a great fit to be able to discuss the VA side of things and how the two worlds intersect between medical certification for the FAA and for pilots and the VA. So,
yeah, absolutely. I'm just really excited to be here. I keep getting a lot of calls from pilots about, this very same issue. So yeah, I think this is a really good topic to discuss.
Perfect. Well, to that end, why don't we give the listeners a little bit of a background on yourself so that they know who you are. Unfortunately, they know a lot about us, but
Maybe too much.
Yes. But if you want to just give us a rundown on what you do, where you've been, and all that stuff, that'd be great.
Yeah, awesome. So started out my adult life. I joined the Marine Corps. I was an enlisted infantryman and eventually was a combat instructor at the School of Infantry West. Ended up getting hurt, messed my shoulder and back up pretty good. So they said I couldn't play around anymore and kicked me out. After that, ended up going to law school because I couldn't figure out what I wanted to do in life. Graduated law school, realized I really liked the law. Kind of messed around with the prosecutor's office for a little bit, prosecuting crimes, then did some criminal defense. And, for the last 3 years or so, I've just been exclusively focusing on military law and particularly veterans law as it relates to the veterans disability system.
Okay, that's cool. I read on your website as well that you spent time in England as well, right?
Yeah. So when I was in law school, I had an opportunity to kind of do like an exchange program where I worked for the Crown Prosecution Service for 6 months, helping them they say, helping them practice law and learning how to do courtroom advocacy, but really it was just kind of carrying my barrister's case files into the courtroom.
Yeah. Yeah, that's cool. Well, yeah, I didn't even.
But it was a good time.
Yeah, that's cool. Well, I didn't have those opportunities myself. I pretty much just hung around the house on the summer breaks. But that's very cool, and it sounds like you're well suited to address these issues with the VA. And I understand, and not to pry, but being a military man yourself, a veteran, you've had interactions with the VA. I'm assuming in your own life as well, so you can speak from that perspective as well as from the perspective of being an advocate for veterans. Is that right?
Yeah, absolutely. That's actually one of the reasons why I started working in this area of law was, I realized how complicated it was as I tried to get my benefits during law school. Eventually I was able to get them, but, it was a pain and figuring out the regulations and figuring out the statutes and how they interacted. It was just crazy. So I started looking to see if there was a lawyer that could help me, and I realized that it was just a really underserved field of law. There's not a lot of people who practice this type of law, and there's even fewer people who do it well.
Sure.
So, kind of my own struggles and the difficulties I had accessing my benefits kind of led me to start this practice and, try and make it easier for other veterans to get the benefits they've earned.
Absolutely. Well, that's very cool. And so as far as practice before the VA, it's my understanding that you have to have special credentials or authorization from the VA to be able to practice in front of them. Is that right?
Yeah, absolutely. So in order to legally represent veterans in their pursuit for benefits, you have to be accredited. For attorneys, the process is fairly simple. You apply for accreditation and prove that you're a member in good standing of a bar association authorized to practice in court. And then the VA will accredit you. With that accreditation comes oversight from the Office of General Counsel, where they overview the way that we handle cases, our ethical obligations to our clients. They review the fees that we charge to make sure that they're reasonable. For non-attorneys, there's actually a way for them to become accredited as well through the accredited agent program. In that program, they go through a background check. They have to take a competency test that's administered a couple times a year. And then they can be accredited to represent veterans as well.
Okay, well, that's interesting. I mean, I think that's going to speak to a point later on that, you have to go through that process to be able to represent an individual, before the VA, which maybe speaks to the level of intricacy that goes into the process in and of itself of getting disability benefits and so on, to the extent that the VA is going to have that much oversight over an individual practicing before them. Whereas I will note on the FAA side of things, and in front of the NTSB, there is no such credentialing. It's any Joe Blow essentially can throw their hat into the ring to try and help an airman or help themselves and so on and so forth. So it's an interesting dichotomy there, just for us lawyer nerds, if you will, that speaks to just an area of practice and the differences there. But to that end, in light of the fact that you have those credentials and accreditation and so on, I understand we've covered that you do handle VA disability benefits in your practice, but can you tell us more specifically about what your practice does in that capacity? Or do you help people get benefits? Do you help them fight when they don't get the benefit? Tell us a little bit about that.
Yeah, absolutely. So, my office is based in Scottsdale, Arizona, but I've got clients all over the country and I've got clients all over the world that I represent in pursuit of their benefits. And what I do is kind of multifaceted, right? I kind of refer to it as knowing the forms to file and helping keep the train on the rails. We, by virtue of being accredited, are not legally allowed to charge fees to help veterans with their initial claims for benefits. So we're happy to do those pro bono for our clients. So if anybody's never applied before and they're nervous about the process, don't know what to do, they can give us a call. We'll help them out pro bono in applying for their benefits. When the VA makes a decision, we're happy to review that decision to make sure it's accurate. Oftentimes, we find in about 70 to 80% of cases, the VA makes some sort of error that is worth appealing.
Wow.
So where we really come in is doing an appeal of a VA decision, either a rating decision where they underrated a particular disability or where they denied entitlement to compensation for a disability. we come in, we figure out what's going on, what issues are preventing the VA from granting the benefit. We aim to solve those issues and then turn a denial into a grant for our clients.
Nice. Okay. So like you said, you go through that whole process from beginning to end, from beginning of applying for the benefits to achieving the right amount of disability benefit for the client. Let me ask you this, Derek. I understand you also handle criminal law as well. Do you represent clients in the intersection between VA disability benefit issues and some criminal liability?
I have. It's not something that's been a pervasive issue here in Arizona, but I do get calls for consultation from lawyers all over the country for assistance when they have clients that have been investigated for fraud or even indicted for fraud because the VA thinks that they've committed some sort of act that is defrauding the VA, whether that's overstating the level of disability or fabricating a disability in some cases. So frequently we do consult on those types of cases. Additionally, in our criminal law practice for veterans who are receiving disability compensation that are, unfortunately sentenced to a term of imprisonment, if they are required to, we assist with notifying the VA so that way they can adjust their benefits according to law. And if eligible, work on getting those benefits apportioned to their spouse or to their kids. So, even though they're incarcerated, their dependents can still get that level of support.
Hey, this is Chris, and I had a question kind of dovetailing off of your statement there regarding investigations into service members who may have overstated their benefits. To me, it would seem that in those circumstances where there may have been an overstatement of what their condition was, wouldn't the VA still have had an opportunity to vet the statement, as to what their disability is, to make that determination before they start getting the benefits? I mean, is that some kind of a defense that could be put forth in those types of cases?
Yeah. So, frequently, one case that comes to mind had an individual who, at the time of the VA disability examination was essentially dealing with a complete loss of use of their legs. They had a disc herniation that they just kind of ignored for too long, and it started to really affect the functioning in their legs. After the disability process, they ended up getting a laminectomy. The disc was reduced. They regained, some pretty good functioning in their legs. The VA, has an opportunity in that case to schedule them for what we call routine future examinations. Oftentimes they don't. And then eventually, the way that we kind of see these fraud cases get over to the VA is somebody's upset that the veteran is getting benefits, or, an ex-wife is mad at them and they make a report. So that was kind of our defense in that case, pre-indictment, was that, hey, it was a legitimate disability. He has no obligation to inform you that he gets better. There's nothing in the law that requires that. It was on you guys to determine whether or not he was still entitled to that, and you chose not to. That's not on him. He didn't commit any fraud. If you want to get a new examination, order it. We'll attend. Mm-hmm. And in that case, we were able to keep an indictment from coming down because, the VA does have that affirmative obligation if they suspect that a disability has improved to get a new examination.
I think that's a really relevant point for a lot of our clients, especially those that might suffer from a PTSD, that the FAA, that's a big issue that the FAA wants to look at, or maybe obstructive sleep apnea, conditions that can resolve over time, or maybe the symptoms not be quite as severe at the time that the individual was examined by the VA and the benefits were put into place. And so, a lot of times clients will come to us and they'll be concerned that, well, I'm getting these benefits for, I'm at 70% PTSD, but now you're trying to tell the FAA that I'm good. How does that, coincide with one another? And we have arguments for that on our end, that, well, we're looking at it from an aeromedically, significant perspective, yada, yada, yada. But I think that's an important point that you just made there. So
and I think we'll hit that in a second. But
Yeah,
in more depth. You need to stick to the script.
This is how I take a depo. I write out the questions, and then I just go off script.
Well, Derek did say something that triggered 2 off-script questions for me.
Oh, okay.
So the first one being, and this is more of a comment, so to the extent that there is a concern for, fraudulent filings and so on and so forth, would it be your perspective that having an attorney or having an advocate perhaps early on in the process for the VA side of things may be beneficial to help, making sure that there's no missteps in that side of things to prevent some sort of fraudulent action down the road?
Oh, 100%. I mean, I'm a lawyer, so I think everybody should consult with a lawyer before they do, pretty much anything. But, where I see a lot of the allegations of fraud coming from are from veterans who are using unaccredited companies to pursue their disability benefits. Companies such as Veterans Guardian, VA Benefits Guide, VA Claims Insider, Trajector. I mean, you can go on and on and on. These companies pop up like, herpes, cold sores. And that's where I see a lot of these issues coming from. And it's not necessarily that the veteran themselves is actively doing anything fraudulent. They don't really know the requirements for accreditation. They don't really know, what these companies do or don't do. But what they're really doing is, they're incentivized to get the veteran the highest rating possible as quickly as possible, because that's how they charge their illegal fees. And the way they do that is they have, their own physicians on staff, their own psychologists on staff that are happy to just rubber stamp a disability evaluation questionnaire or disability benefits questionnaire to get, the highest rating possible, whether or not it's actually medically supported. And these companies will then submit this information to the VA as if it's the veteran submitting it. And from the VA's perspective, it's the veteran who's submitting this, the veteran who's signing off on this, the veteran who's saying, yes, this is this medical exam, which says that I cannot, move my back at all without excruciating pain. And I'm 100% disabled because of my major depression. When that isn't at all accurate or borne out by the records, that's where I'm kind of seeing a lot of the fraud allegations come from, rather than veterans themselves actually going out and actively perpetuating fraud intentionally.
Interesting. Yeah, and that'll dovetail as well into our sort of discussion on the falsification side, on the FAA side of things, and as to the airman's actual knowledge of what's going on with their medical history and really the severity of their underlying medical condition as it relates to aeromedical significance for the FAA. But that was question number 1, and then I promise we'll get back to the scripted questions. But number 2 was, you had indicated that in these fraud cases, for example, that you can stave these things off before indictment, right? And so one of the things that we hear a lot from other airmen is, they're concerned that, hey, how do I know I'm not going to go to jail, or I'm not going to have be indicted and so on? Can you give us an idea of what that typically looks like when it running up to an indictment? Are there signs? Are there indications that, hey, this might happen, that maybe an airman or a client should look for before they need to really start worrying about an indictment?
So typically the way that I kind of get cued that there's an investigation in the works is when somebody calls me and says that the Office of General Counsel or the Office of the Inspector General or a special agent with one of those entities has reached out to talk to them. At that point, that's when I kind of realize, hey, something's going on. So if I get retained at that point, I reach out and I talk to the agent that's handling the case. I figure out kind of what they're looking at, what their concerns are. And then I figure out a way to address those. Not every single time, not every single investigation ends with a referral to the U.S. Attorney's Office, and not every single referral to the U.S. Attorney's Office ends in an indictment. So really, once you're contacted by law enforcement in any capacity, that's the time when you need to be retaining an attorney, because, at that point we can jump in, we can clear up any misconceptions or misunderstandings and do what we can to prevent criminal charges from being filed.
Good. Okay. That makes good sense. I think that's good advice. And I think it's the same for the FAA side of things to a certain extent. Once you get a letter of investigation, you should certainly retain or discuss with counsel. And there are opportunities on the FAA side that there are indications that you can kind of say, hey, maybe I can get ahead of this before there is an opportunity for investigation by the FAA. But that's a good answer. That satisfies me for sure. But kind of moving on, more generally, kind of back to where we were before we got sidetracked there. The VA disability application, if you will, internally at the VA. Can you give us a little bit of a rundown of what that process looks like? I know there's a lot of airmen out there and clients that have seen this side of things. They've seen what they've gone through to get the benefits. But can you speak to kind of what happens in that determination process on the VA side?
Yeah, absolutely. So when the VA receives an application for disability benefits, the first thing they do is review it for completeness, and then they determine eligibility of the veteran for those benefits. In order to be eligible for benefits, you have to have a certain amount of service. You have to have a certain characterization of discharge. They kind of do those preliminary checks for eligibility. After that, it gets reviewed to determine whether the VA has an obligation to provide medical exams and opinions. It's a very low bar in that case. If there's really any reasonable indication that a condition could be related to service, the VA will then order examinations. Typically, those examinations are conducted by a third-party contractor, such as LHI, QTC, VES. There's a bunch of them. The veteran will go to those examinations. The medical examiner, typically a nurse practitioner or physician assistant, will conduct an examination and then render an opinion as to whether or not that condition is at least as likely as not caused by service, a specific event in service. Once all of those exams are completed, it goes back to the VA, where a rating veteran service representative will review the examinations and then make a couple of determinations. The first is this benefit service connected? The second is, if it is service connected, what is the rating that the law prescribes for this level of disability? And then the third is, what is the effective date, or what date do we start paying this veteran for this disability? After that, it goes through a couple rounds of review, and then it gets sent out to the veteran with a decision.
Okay. And as far as if the VA were to decline a service connection, or if you feel as though you weren't rated appropriately, there are appeal processes for that. Is that right?
Yeah, absolutely. So there are 3 lanes of appeal, and in one of those lanes, there's 3 other lanes. So the broad strokes are, if you are denied service connection, you can, or you're not happy with the initial rating, you have sort of 3 options. The first option is you can file a supplemental claim by providing new and relevant evidence about the issue of service connection or the issue of an appropriate rating. The second option is you can do what's called a higher level review. It's a closed record, a de novo review by a senior decision review officer who will then look to make sure that the law and the facts as they were known at the time of the decision were properly applied. And then the third option is you can always appeal to the Board of Veterans Appeals, where a veterans law judge will then determine the issue of either service connection, rating, or effective date. At the board, you have 3 options to choose from. You can go in the hearing lane, where you will get a hearing in front of a veterans law judge. You can explain your theory and the evidence and why you think you're entitled to the benefit. You can go in the evidence submission lane, where you can submit additional evidence, but you don't get a hearing with the judge. Or you can go in the direct review lane, which is another de novo review based on the evidence and law as it existed at the time of the decision.
Okay. And so definitely if you're a veteran and you've gone through that process up to that point alone, certainly at that point it would be warranted to contact an attorney. Although, of course, contacting an attorney first would be the optimal decision. But at that point, having someone such as yourself walk you through the appeal process would be a good idea, I would say.
Yeah, absolutely.
Yeah.
If you make a claim for benefits to the VA and they don't grant everything to the fullest extent of the law, it's always worth it to have, an attorney or accredited agent take a look and see if everything is correct, or if not, what we can do to correct that decision. The VA appeals process is fairly favorable in that there is a 1-year period from the date of decision to actually appeal that decision. After that 1-year mark, you can still reopen with a supplemental claim, but the option to do a higher level review or go to the board are foreclosed if you wait more than a year to appeal.
Okay, that's good info. And let me kind of back up through the process with another random question, one which I think is relevant to our clients. When you go through the CMP process, through those examinations to get your benefits, the results of those evaluations, as I understand it, generate a report called the CMP report, or CMP exam report. On our end, if typically the FAA would love to see those evaluation reports, most of the time they're not something that can be produced, just because by the time the FAA wants those evaluation reports to be produced, getting those CMP exam reports are next to impossible, or they take 6 months, 12 months, or longer to even get a copy. Is that something that the veteran will get throughout the process, or is that something that just goes into the VA and that's that?
Yeah, so it kind of depends, right? If a VA medical examiner, so a VA employee that is doing the compensation and pension exam, that will be available in their VA medical record. Most exams are done by third-party contractors, and those are kept in their VA claims file. Now, as an accredited attorney, I've got instant access to everything that's uploaded to the veteran's claims file. But unfortunately, veterans don't get access to their DBQs, their disability benefits questionnaires, or the exam reports, unless they fill out a FOIA request and request a complete copy of their claims file, which, as you said, can take 6 to 8 months or even longer. So that's just another reason why it's important to have an accredited attorney early in the process, because, one important thing that we do with our exams is we send a copy to our clients almost right away, because a lot of these disabilities are rated based off of how a veteran reports their symptoms. And unfortunately, a lot of these nurse practitioners and physician assistants don't accurately report what the veteran's telling them. So, we send our clients their examination reports fairly often, and we're happy to do it upon request, of course. But for the veteran themselves that's not represented, it can be very difficult for them to get access to their examinations.
Absolutely. Yeah, we can attest to that ourselves here. That can be a difficult process, to say the least. So I would recommend, if you are a veteran, then you have access to those reports, at the time of application, as Derek indicated, to retain a copy of that, or else, if you're going alone, which you shouldn't, it will put you in a spot where getting those records that the FAA may want to see on the airman medical certification side of things can be difficult. Well, with that being said, Derek, we kind of got the broad strokes out of the way. I wanted to kind of dig down into some of the questions that we hear on a regular basis. Some of these questions are bore out of litigation that we've had, as far as the thought process behind the VA disability benefit process when it comes to an airman's perspective. So it may just be random questions, to be honest with you, but these are things that we hear a lot and are asked a lot. That does dovetail, I think that's right, dovetail into sort of the FAA certification process. So starting there, we hear this one a lot. Is that, hey, I have to claim this disability, I have to claim this condition as a disability and get benefits for it in order to get treatment for the condition from the Department of Veterans Affairs later on in life. Is there any water? Does that hold any water? Is that accurate?
It does hold a little bit of water. The VA is obligated to provide complementary care for service-connected conditions. However, once a veteran reaches 50% or more in a combined disability rating, all of their medical care, regardless of whether or not it's service-connected, is covered by the VA. So if they're rated more than 50%, they don't necessarily need to be service-connected for a condition to get medical care for it later on in life. If they're rated under 50%, they're still eligible for treatment from the VA, but it wouldn't be free. They would have to pay a copay.
I understand. Okay, that's good to know. And I think good for the listeners to know, because that is a frequently misstated and I think misunderstood element, especially when it comes down to this thought process by a lot of airmen that, they never felt as though they really had a condition, but they essentially applied for the benefit just to preserve that opportunity down the road, which then becomes relevant as to whether or not they think it's relevant to report the condition and the disability benefit to the FAA on their medical application, which dovetails into the next question.
Has your FAA medical certificate been denied? Are you concerned you may not be able to get a medical certificate from the FAA? Are you at risk for FAA action for failing to report your medical history appropriately? Call the pilot lawyer at 1-855-FAA-1215 to discuss your options for getting the FAA to issue your medical certificate and get you flying. We are happy to evaluate your case and discuss with you a plan for presenting your case to the AME or the FAA. Aviation law is all we do, nothing else.
This idea that a lot of individuals that we work with, and they're contacted by the FAA about perhaps not having appropriately reported their VA disability benefits. As we dig into the file, and as they dig into the file, and they see, and the FAA digs into the file, they begin to see things that maybe they're being compensated for that they were unaware that they had even applied for. I didn't know that I'd ever been diagnosed with diabetes or, whatever it may be that they're getting benefits for, or they at least applied for the benefit and was found to be not service connected. Is that something that in your practice that you could find to be feasible, that maybe somebody has applied for a benefit that they didn't even know was something they had?
In a sort of abstract sense, yes. And by that, I mean, the idea when you first make a claim for benefits is to make as broad a claim as possible. So rather than specifically applying for, say, irritable bowel syndrome, you would apply for something called like a bowel condition, because the VA has a duty to broadly and sympathetically read a claim for benefits. So we generally don't want to artificially narrow the scope of the claim. So we make a broad contention. Now, when you go to the exam, the examiner will examine you and then render a diagnosis if appropriate. And that diagnosis might be something different than what was claimed. For example, I had a client who claimed foot nerve damage. But on the examination, there was no nerve damage. It was plantar fasciitis. So when he was rated for plantar fasciitis, not foot nerve damage. And he was a little confused until I was able to explain that, the symptoms he's feeling were more likely due to plantar fasciitis rather than a nerve issue. So in that sense, it's possible to get benefits for a condition that you didn't necessarily apply for. But in terms of getting benefits for a condition that you don't have, that would be very strange. Okay. That raises some red flags to me, honestly.
Sure. Yeah, it usually does to us. But that's a good answer, I think, that explains. I think, again, when people apply, like you said, they apply more broadly and then they get a more honed disability benefit. I think that disconnect is one that is relevant to the FAA. I think it's the FAA process, because the FAA is looking for specific diagnoses rather than broad issues. And I think there is a disconnect there, and it's something for people to keep in mind, that they know exactly what they're getting their benefits for rather than just, hey, my stomach problem. Well, it turns out it's actually, colitis or whatever it may be. Right. So,
yeah. And that's why it's important to read the rating decision, that is sent to you from the VA, because it'll list out what they decided, what they rated the claim as. Let's say something like service connection for Crohn's disease claimed as bowel condition. And then, okay, they diagnosed me with Crohn's disease. It just becomes kind of a problem, like you said, because, unless you're taking the time to read through that 35-page packet the VA sends you, you may not know what was diagnosed at the C&P exam because you don't get a copy of those C&P exam results.
Right. That is important. Let me ask you this to follow up to that. The FAA relies heavily on these VA decision rating sheets to sort of establish that in falsification cases that the airman knew, or essentially should have known, that he or she was receiving disability benefits from the VA. And so What is the method like in which an airman or a veteran were to receive that this decision rating sheet? Is that sent certified mail? Is that sent regular mail? How does the airman have, or the veteran have access to that?
So they get access to it in two ways. The first way is it'll be sent to them in a packet via regular mail. Unfortunately, a lot of people are bad at updating their address with the VA, or the VA just sends it to the wrong address. So they may not get that packet in the mail. But when they log into their VA.gov account, or that used to be called e-benefits, there is a section where you can see all of your rated disabilities, what they're rated as, what the condition is, and what level they're rated at. So they can look online in their VA.gov account or check their mail, assuming that the VA has properly mailed out notification.
Sure. Okay. Again, that may seem like a trivial question, but one of the big issues with the FAA is that in defense of a falsification case, the FAA has to prove three things under what they call the Hart v. McLucas factors, which I'm sure you're familiar with. And those three factors are essentially that you, one, made a false statement, two, that you made it in reference to material fact, and three, that you had knowledge of the falsity. Essentially, knowledge of the falsity is the element that kind of smacks people around the most when it comes to these issues, because it gets into the nuance, and we talked about this more, but it gets into the nuance of the airmen believing that their disability benefits weren't actual disability benefits because the application asked for a history of a lifetime receipt of medical disability benefits. And so as a result, a lot of people don't perceive their disability benefits to be disability benefits. They perceive it to be compensation for their service. But beyond that, establishing whether or not you knew you had a false statement when you said no to that question, when really you're receiving 50% disability benefits for various conditions. The problem there is that the FAA will typically whip out documentation showing that your VA decision rating sheet, they'll show, sometimes even the CMP exam results and so on and so forth, to establish at least some circumstantial evidence of knowledge. And so I think it's important for airmen, especially those that are in the lineup for defense of a falsification action, to consider the fact that that argument may not get you very far, that you didn't know about these benefits, because not only is it provided to you in the mail, but now as times are changing, this information is accessible at the internet. And then beyond that, the FAA will also establish that, hey, listen, you're getting these direct deposits, or you're getting these checks. Whatever the source of payment may be, you're also getting these checks. You're getting money every month or whatever. And how do you account for that? So it's good to know that, even though that's a trivial thought, how do the people know? Is this element of how the airman or the veterans being notified of this information is an important thing to keep in mind, especially if you're pursuing a defense in a falsification action with the FAA. Going in there and saying, "Hey, I didn't know I was getting benefits," is not gonna get you anywhere. Just because that can be. It took Derek maybe 7 seconds to answer that question, and that's how long it'll take the FAA as well. So
yeah, exactly. The law, knowledge is new or should have known, and the fact is that it's easy to figure this information out, and if you're not figuring this information out, you're kind of just sticking your head in the sand, and that's never a legal defense.
Yeah. So head sticking in the sand is definitely not a defense, and that brings me to the next point. So one of the most concerning pieces of reporting disability benefits, I think, to a lot of veterans and a lot of airmen is that, one, either A, I'm not going to get my medical certificate, or B, I'm going to lose my VA disability benefits. That's concern number one. That dichotomy. But then there are also people who I think genuinely are naive to the idea that their disability benefits are disability benefits. I have heard that a lot. I think the people that believe that are genuine in that thought process, but it is a bit, at times, can be naive. But I think more so we'll see cases where people are just legitimately concerned about, they're not going to get one or the other. They're not going to be able to have both. And so one of the questions I have here for you if I apply for a medical certificate and I have VA disability benefits, and I identify for the FAA that, hey, I'm getting 50% for obstructive sleep apnea, for example, the FAA has protocols in place for which you can have obstructive sleep apnea so long as you're effectively treating it with either a CPAP or a dental device or whatever it may be to get what they call a special issuance authorization. But if I do that, am I going to lose my VA disability benefits? Can I have the best of both worlds, if you will? I think that's the question that I'll pose to you. But also at the same time, when in your response, what if I go to the FAA and I report my sleep apnea, but I go and do a new sleep study and it shows I no longer have sleep apnea, and I show that to the FAA, and the FAA gives me a medical? Can I still keep my disability benefits in that case?
Yeah, that's a great question. So what I'll say is that, the FAA seems to be able to pull some information from the VA, but the VA doesn't pull information from the FAA. So unless there's, a investigation going into a veteran's case, the VA isn't going to go out and grab a copy of that medical certificate or whatever information you provide to the FAA. And that kind of goes into what we were talking about earlier, where, the veteran doesn't have an affirmative obligation to report improvement in their symptoms. That's on the VA. So if you have obstructive sleep apnea and it's service connected and it's treated with a CPAP, and then you manage it with diet and exercise and get to a point where you no longer have sleep apnea, the veteran doesn't have an obligation to report that to the VA, and the FAA isn't going to turn around and report that to the VA. Really, it seems like the intersection of VA and FAA as it pertains to medical certificates is the FAA pulling information from the VA rather than the VA getting information from the FAA. Does that make sense?
That's perfect. Let me ask you, let's go a step further. For example, we've seen cases where maybe an airman's rated 30% for PTSD. And the FAA says, we want a current evaluation on this PTSD. And largely, our perspective is that, we're not going to go in there and say you never had PTSD. We're not going to say, hey, that's bogus by any means. Instead, we're going to look at its aeromedical significance, sort of acknowledge the existence of the PTSD, the historical existence of the PTSD. And we're going to look at, is this something that's going to affect this individual while he or she is flying or in any type of aviation risk capacity? And if so, can that be mitigated through counseling or medication and so on and so forth? But that being said, we have had cases where the airman, again, hypothetically, is receiving 30% for PTSD, sees what's known as a HIMSS-trained psychiatrist or have some other mental health professional say, you know what, I don't think this airman really ever had PTSD. In those circumstances, again, this is sort of a different context than the VA disability process. Let's say the airman were to put forth that report to the FAA, good faith, evaluation, not trying to pull the wool over anybody's eyes, but it's just a difference of opinion by this third-party psychiatrist. Do you perceive the VA having a problem with that, even if they did find out about it?
No, because symptoms can wax and wane, and PTSD is at its core like an anxiety condition, and it can be mitigated through treatment to the point where, someone with PTSD can get treatment to the point where they no longer meet the diagnostic criteria. In terms of, if a third-party psychiatrist with the benefit of hindsight goes back and disagrees with that initial diagnosis of PTSD, well, that doesn't really matter for the VA's perspective. They're not able to sever service connection based on that. They're only able to sever service connection if it was based on fraud or if it was clearly and unmistakably erroneous based on the information at the time of the decision to grant service connection.
Okay.
So it's really hard. The VA wouldn't really do much with that. They might use it if they got a copy of it to schedule a re-examination to determine the current severity. And they might, if there's no more symptomology to warrant a diagnosis for a mental health condition, they might reduce that benefit to 0%, but it wouldn't sever service connection, if that makes sense.
Okay. That's a great answer because that probably the number one question we get. I mean, we don't influence any of the psychiatric evaluations or any of the evaluations that we have with our clients undertake, but frequently we'll see cases where, HIM psychiatrists or specialized aviation psychiatrists will kind of disagree with what's going on with these initial CMP examinations just because the facts aren't there in their perspective. And, it's just a perspective. Everybody's got one. But that being said, that is a big concern for a lot of airmen that they're going to somehow present now a perspective to the FAA that's different and contrary to what's being presented to the VA, what was presented to the VA. Now, of course, I think you would agree with me, Derek. You don't want to go to the FAA, say, hey, this psychiatrist doesn't think I have this, and then on a re-exam, say the VA wants a re-exam. Now, all of a sudden you say, actually, I really am not doing too well, to try and maintain your benefits at the capacity.
You got to pick a lane.
Yeah. At that point, I think you certainly need to pick a lane. Would you agree with that?
Yeah. I always counsel my clients to be honest and consistent. And what I really run into more than, my clients trying to over-report or exaggerate their symptoms, the biggest issue I have is clients who under-report or minimize their symptoms. So, when I prepare clients for examinations, most of it is like, okay, what's going on with this? Okay, no, you're not doing okay. You're having nightmares every night.
Sure.
That's what you told me before. So, when they ask how you're sleeping, don't say great, tell the truth. I think that if people are just honest with their examiners and they're not trying to get a certain outcome, then they have nothing to worry about, because whatever they're doing is proper.
Sure. Now, there are some conditions, though, on the FAA side, very few conditions, but there are some conditions where we have to go to the FAA and say, this person doesn't have this condition. They never had this condition. The person that evaluated this individual was out of their minds when they made this determination. So, for example, we're looking at like bipolar disorder, psychosis, a personality disorder that's manifested itself through repeat overt acts, those types of more severe mental health conditions. In those capacities, there has to be the FAA won't consider mitigating factors. It's not like you can have bipolar disorder and technically be mitigated through ongoing counseling or, lithium use, that type of thing. So in that capacity, if somebody has the benefit for that, we have to go to the FAA and say, listen, this condition is not accurate. At that point, would you feel there's an obligation for the airman to go back to the VA and say, look at this again? Or is there an opportunity to renounce those benefits for that condition? And if so, what would that process look like?
Yeah, so great question. I'm going to answer it in kind of two parts.
Sure.
The first is that comparing the standards for a diagnosis and a rating under the VA rating schedule and the VA regulations, and comparing that to diagnostic standards for, what I would assume be like an FAA medical cert, is kind of comparing apples and oranges. And by that, I mean, everything in the VA benefits system, everything in 38 CFR parts 1 through 4 is designed to be pro-veteran. So if there is any doubt whatsoever, that doubt has to be resolved in the veteran's favor. So if there's doubt about a diagnosis, well, we're going to err on the side of granted benefits and find that diagnosis. The standard by which a VA psychiatrist or psychologist is determining a diagnosis is different than what a FAA, flight examiner or flight medical examiner would be looking at. And with that difference comes, a wide range of difference of opinions where, it could be kind of questionable whether or not this veteran has, this particular diagnosis, but we're going to resolve that diagnosis in his favor versus, a medical examiner who's going to do objective testing, who's going to do extensive interviews, who's going to research the condition and then render, a more definitive opinion. So in that regard, sure, it's not a straight one-to-one comparison between, the VA diagnosed me with this, but this medical examiner disagrees. And then when it comes to renouncing benefits, that's tricky because if you're going to renounce, you have to renounce all of your disabilities. You can't just say, I want to renounce the mental health disability, because then you're going to lose your back and your knees and the other stuff you may be claiming. So renouncement is not something that we typically do in my practice because, one, the liability alone, my malpractice carrier would
sure
raise my premium.
Yeah. You'd have to charge us to be on the podcast at that point. Yeah.
Yes, it is possible to renounce benefits, but it's probably not a good idea, because I would assume that there's probably a way to contest the propriety of a diagnosis rather than, renouncing. And I would assume that even renouncing the benefit doesn't remove the fact that there was a diagnosis for it in the first place. Yeah,
that's absolutely right, because the application for medical certification has in your lifetime. So even if it was renounced, at one point in your life, you did have the benefit, so it would still trigger a response to the FAA. I would tell you that we've had individuals that have contacted us, and by the time they've got to us, they've been down to the VA trying to renounce their benefits, thinking that will help. And I've heard tales from individuals that they went down to the VA and they're essentially laughed out of the office, that there's no way they're going to let them renounce their benefits. So it's not to say it can't be done, but it is something that I have found in the clients that have tried to make that effort is very difficult. It's just unheard of. It seems like down at the VA.
Yeah.
But
to renounce, you have to do it in writing, which you can't just go down to the VA and say, I want to renounce my benefits. You have to do it in writing with a wet ink signature and, file that with the VA. It can be a fairly involved process, but it's usually not a good idea.
Yeah, that makes sense. Well, Derek, I know we're running out of time, but I just wanted to touch base on one more issue that's pretty important to a lot of our client base, especially is this what they call the VA special project at the FAA. And as I'm sure you're well aware, you've probably spoken to more pilots lately than usual, but it's a situation where essentially the FAA was receiving information from the VA relative to individuals who are receiving disability benefits. And it's our understanding that, in that process, that information had been provided to the FAA pursuant to regulation by the VA under the VA heading that authorizes the release of information relative to disability benefits to other governmental agencies such as the FAA. And as a result of that, there was an effort to cross-reference individuals who had reported and who had not reported their disability benefits on their medical applications, which resulted in a sort of a tailspin at the FAA, in my opinion, from anything from airmen losing their airman certificates and medical certification to getting a slap on the wrist to essentially there being no action taken whatsoever. And that's sort of an ongoing concern that we're seeing at the FAA with how they're handling some of those cases. But to that end, on the VA side, in each individual that gets a letter of investigation or has some interaction with this special project, we have seen a few cases where airmen have been contacted by special investigators from the Office of Inspector General for the VA Criminal Division. Is there any advice, and I think we touched on this early on, but is there any advice you can provide to those individuals that maybe have been contacted by somebody in the investigative realm on the VA side of things?
Yeah, the same advice I'd give any client that's being investigated by any government entity. Don't answer any questions without an attorney present. Let's say you get a knock on the door, you get a letter, and it's a special agent, that wants to talk to you. Be polite. Say, hey, I'd love to talk to you. I can't do so without my attorney present. Can I have your business card? And my attorney will reach out. Yeah. And leave it at that.
Okay.
Let your attorney handle it from there. You're not really ever going to be able to talk your way out of an investigation if you're the subject of that investigation. The only thing you could really do is dig your hole even further.
Sure.
So, anybody that's being investigated or anybody that's being contacted by law enforcement in connection with an investigation, just tell them that, you don't want to speak to them without an attorney present, get their contact information and leave it at that. Okay.
Yeah, I think that's good advice. And as far as contacting an attorney, of course, if if you're able to handle the case, I highly recommend you, Derek, of course. But is there somebody, some sort of specialty that the client should look for? Should it just be a VA attorney? Should it be a criminal attorney? Any recommendations there?
So the VA benefits law space is kind of interesting because most of the folks who practice this area of law come from another area of administrative law, like Social Security or something like that. So there's not really a lot of attorneys that kind of dual hat in criminal law and veterans benefits law.
Sure.
So, if you're the subject of an investigation, I recommend retaining a criminal defense attorney and making sure that they're familiar with the VA disability benefit system. And if not, ensure that they're going to consult with an attorney that is familiar. I fortunately have a lot of experience doing both. So, if people are the subject of an investigation, I'm happy to talk to them and see what we can do to resolve it. But if they want somebody more local, any criminal defense attorney who practices, federal criminal defense can get the process started. They'll probably end up reaching out to someone like myself or another attorney, for some information and color on the case. But yeah, anybody that's being investigated for potential crime should reach out to a criminal defense attorney.
Okay. And Derek, if somebody wanted to get in touch with you, how would they go about doing that?
Oh, awesome. So, my website, my firm is Stone Rose Law. So you can find me online, www.stoneroselaw.com. You can reach me by email at Derek, DEREK, at stoneroselaw.com. I'm on Twitter, Derek_Debus. You can call my office, 480-498-8998. Any way you want to get a hold of me, I'm happy to talk to people.
Okay, absolutely. Well, we certainly will keep sending folks your way. We hope that they will gain a lot out of your appearance on this podcast. I know that I've gotten a lot out of it, for sure. I deal in this space, if you will, every day. And so I think, again, it's coming
reassurance.
Back. Yeah, it's reassurance. Yeah. I haven't been malpracticing all over the place. So that being said, I think anybody that's going through this process, whether you're applying for benefits, you're on the other side of benefits, haven't reported your benefits, you need to amend your applications to the FAA. This is a good one to listen to. It's not us Ison Brothers just rambling on the whole time. but
yeah, this is a good one. I appreciate you guys having me on.
Yeah, absolutely, man. Well, if you need anything, let us know.
I will do. I'll keep sending pilots your way if they come through.
Well, thank you so much, Derek. It's good talking to you. We'll send you a link to the episode when it's complete, which should be hopefully Friday. So.
Oh, sounds good. I'm good. Look forward to it.
All right. It's good talking to you. Thanks so much.
Good talking with you.
Well, you've logged what appears to be over an eventful hour, listening to the Pilot Lawyer Podcast. I think we've gotten a lot of good information out of Derek today as it relates to VA disability benefits.
That was some of the finest content.
Yeah. That answered. We should probably pay a consultation fee to him because that was it was impeccable.
He answered all your questions that you've been asking me around the office for months. And I tell you, hey, go. You're a lawyer. You go do the research yourself.
Yeah. So I think we got some great advice to kind of recap. Just because you're getting disability benefits doesn't mean you can't get an FAA medical certificate. And I'll tell you on our side of things, just because you have a benefit for PTSD or diabetes or OSA, you have opportunities to get a medical certification. You just need to be honest about it with the FAA to avoid this turning into a snowball event, right? So I think that's number one. Number two, you want to consider what information is out there to you, especially if you're caught up in the special project. You don't want to be going forth with defenses saying, hey, I didn't know I had disability benefits and so on. As Derek stated, there's a lot of info out there that can give you enough information to establish that you did know you were receiving disability benefits. Also, if you're working with somebody to get disability benefits from the VA, ensure that it's one of those accredited entities. I recommend Derek for sure in that capacity, but definitely a VA benefits attorney would be something we would recommend to make sure that your intersection between the FAA medical certification process and the VA process is as clean as it can possibly be. But with that being said, I think that pretty much wraps things up for this episode. Again, even though you've logged an eventful hour listening to the Pilot Lawyer podcast, we hope that you will join us again soon on a more flippant episode next time. And even though our wives are starting to cozy up to us, they've heard the good content. They acknowledge that these
guys might be keepers.
These boys might know more than we think they do. We are the Ison Brothers, the Ison Law Firm. We'll see you next time.
I think that just killed that sentiment.
This is thepodcastfactory.com.